Good afternoon and welcome to this beautiful fall day on behalf of Virginia Board for People with Disabilities and our Alumni Development Program Training Alumni. I, Dr. Penny Sweetenberg Lee, who serves as the Director of Training and Alumni Development Program, welcomes you to another exciting, educational, and informative statewide workshop. Today, our session is entitled Planning a Life with a Disability, Financial, Legal, and Support Strategies. I first want to introduce you to our training alumni. The training alumni consist of graduates of two of our flagship training programs, Partners in Policymaking, which we affectionately call PIP, and or our Youth Leadership Academy, that we refer to as YLA, formerly known as the Youth Leadership Forum. The mission of the training alumni is to provide advocacy trainings and continuing education workshops focused on the broader disability community in the Commonwealth of Virginia. In order for us to deliver these sessions, it requires a collaborative effort from members of our agency as well as individuals that we hire to help us deliver these sessions. And I would be remiss if I did not acknowledge, first of all, our Executive Director for the Virginia Board for People with Disabilities, Ms. Terry Morgan, whose leadership and support allow us to present these trainings to the Commonwealth of Virginia. We also want to acknowledge our administrative team members, Mr. Henry Street, who serves as the director, and Ms. Tara Bethea, our board administrative specialist. Our communication team, Ms. Anita Ayers, communications and information manager, helps us to make sure that these sessions are streamed on our agency webpage through our Facebook page. So it is being recorded live on Facebook and you can access it following the session and through eternity on the Facebook page at Virginia Board for People with Disabilities. We want to thank Anita and certainly her assistant, Ms. Brittany Hughes, and we welcome as our closed captioner today from Virginia Relay, Ms. Julia King. Representing Boitnott Visual Communications, known as BBC, we welcome our guru, Mr. Eli Red. We want to thank DARS Procurement for helping us with all of our procurement requirements and responsibilities. And we welcome as our interpreters today, representing the team is Ms. Bernice Venuto and Ms. Liz Leach. Bernice and Liz are senior interpreters who have worked with Virginia Board for People with Disabilities for many, many, many years. And we thank our director, Ms. Nia Harrison, who serves as the Planning, Research, and Evaluations Director for Virginia Board, who is responsible for making sure that all of our trainings are evaluated. And I would like to thank our Alumni Development Program Coordinator, Ms. Christine Jermeyer, who is the right and left hand and helps to make all of the logistics work. So a special thank you to the production team. You have seen already that we have a poll that is up. The first poll is to find out who is here, and we call it the About You poll. We encourage you, it is anonymous, but we encourage you to please take the poll for us. At the very end of the session, this session will run from 12 noon to 2 p.m. and we endeavor to be on time. But we would ask that all of our participants please stay on with us until the last evaluation poll is put up. And we will do that approximately 5 minutes before the session ends so that you'll have an opportunity, those who choose to give us some session feedback. If you are in need of an alternative format, We ask that you would drop that into the chat and we will certainly accommodate you. Or you may email nia.harrison@vbpd.virginia.gov following the event. If you have additional needs, please email us at trainings@vbpd.virginia.gov and we will get back with you. Today, our agenda will move as follows. We will introduce our first presenter. That presenter has 15 to 20 minutes that will include questions and answers. And then we will move to the second presenters, followed by our third presenter. We are very happy to have Ms. Brittany Bullock representing Commonwealth Savers. She serves as the Able Now Outreach Specialist. We have Ms. Kristen Carlton, who is the Chief Executive Officer for All Needs Planning, and her co-presenter is Dr. Kathy Matthews, who serves as the Chief Clinical Officer and Family Strategist, also at All Needs Planning. And bringing up the rear, last but not least, will be attorney Nick Thompson. He is an adjunct professor of law at William and Mary Law School, and he is the managing attorney for Elder and Disability Law Clinic. We are happy to have all of them join us today. And following their presentations, we will have Q&A following each presenter. And then at the end, if there are additional questions that come in the chat, then Christine Jeremiah and myself will assist with that. And we will conclude with some final announcements and the final session feedback poll. Having said that, let me now turn it over to Ms. Brittany Bullock, representing the Commonwealth Savers. The Commonwealth Savers is a state agency, and we are delighted to be in partnership with them, representing Able Now. She is an outreach specialist.
Thank you so much. I'm going to
take it away.
Share my screen here. All right, well, good afternoon, everyone. My name is Brittany Bullock. I am the outreach specialist with the Able Now program. And my hope is that a lot of the attendees today are familiar with Able Now, or at least have heard of the Able Now program. I'm going to give a very brief introduction to Able Now today, but I will say if you have additional questions or want the full presentation, our website is going to be a great resource for you. So what is ABLE? ABLE accounts are relatively new savings tools specifically designed for eligible individuals with disabilities that allows for them to save private funds to help pay for qualified disability expenses. So those of you listening onto the call today know that for far too long, individuals with disabilities were not able to really save money for the fear of losing their public benefits. And so for most individuals, you know, they can save up to $2,000 before, or have up to $2,000 in assets before those benefits are reduced or suspended. So the idea for ABLE actually came about 15 years ago when a group of parents in Northern Virginia sat down and they were a little frustrated that they could save for loved ones without disabilities, but they couldn't really save for their loved ones with disabilities. So they kind of worked and advocated to change that inequity, and that's where the ABLE Act came into play. And so ABLE stands for Achieving a Better Life Experience. And again, it's a tax advantage savings account for eligible individuals with disabilities. With the ABLE Act, it allowed for individuals to be able to save up to $18,000 per year without endangering eligibility for certain means-tested disability benefits, such as like SSI, SSDI, and Medicaid. I do want to know, and I'll kind of mention that the contribution limit is tied to the gift tax. And so when ABLE first started, the contribution limit was $14,000. And if that gift tax ever changes at the federal level, those ABLE contribution limits will change as well. Another nice feature with the program is there's something called the Able to Work Act, where working account holders who are not participating in an employer-sponsored retirement plan can actually save above the annual contribution limit thanks to the Able to Work Act. And for 2024, that maximum amount would be around $32,580. But for most of our account holders, they are going to abide by that yearly annual contribution limit, which again for 2024, it is going to be $18,000. The ABLE Act, just a quick note, was passed into law in 2014, and it actually modified the U.S. Tax Code Section 529, and that's what opened the door for ABLE accounts. And then here in the Commonwealth of Virginia, we're really fortunate because we were one of the first states to pass it into law at the state level. So Virginia passed it into law in 2015, and we also like to say that ABLE started here in the Commonwealth of Virginia. Mr. Stephen Beck Jr. Was the individual who really advocated for ABLE accounts. And his daughter, Natalie, was actually one of our first account holders. So again, ABLE stands for Achieving a Better Life Experience, and it's offering tax advantage savings accounts for eligible individuals with disabilities. So what is ABLE Now? ABLE Now is the largest independent direct sold ABLE savings program in the country, and we opened in December of 2016. Although ABLE is the Commonwealth of Virginia's ABLE Savings Program, we actually have nationwide enrollment. So maybe you're working with an individual who lives in Virginia now, but wants to move later on or has to move later on. The great thing is that they can keep their ABLE Now account with us. And today we actually do have ABLE accounts in all 50 states, ABLE Now accounts. ABLE Now is administered by Commonwealth Savers, formerly known as Virginia 529, and Commonwealth Savers is an independent state agency of the Commonwealth of Virginia, and we manage programs like the Invest 529 program, and we also have a private retirement program as well. So again, ABLE Now is the direct sold ABLE savings program offered by the Commonwealth of Virginia. And you're going to open and manage your account directly on our website, ablenow.com. So a question that I receive a lot when I'm out speaking with families or individuals is how do we know if we're eligible for an ABLE Now account or if our loved one is eligible? So currently, an eligible individual is someone who developed the onset of their disability prior to the age of 26, and they are entitled to supplemental security income or Social Security disability insurance benefits based on their blindness or disability, or they can actually self-certify that they have a qualifying disability diagnosis through their physician. So I like to say we have a nice split between those who are qualifying because of their benefits or because they're going to self-certify. It is very important to note that an individual can only have one ABLE account at any given time. So if an individual is opening an ABLE Now account, they wouldn't be able to go open an ABLE program with another state or have a second ABLE Now account. Now, we do have some great news about the age limit or the age restriction. So our team, advocated with a lot of other states to really push the ABLE Age Adjustment Act. And that was actually passed into law in 2013. And what this means is that beginning in January of 2026, ABLE eligibility will extend from onset of disability prior to age 26 to onset of disability prior to age 46. So this means in the future, millions of more people with disabilities will be able to take advantage of this important savings tool. But again, currently onset of disability is prior to age 26, and they are either entitled to SSI, SSDI, or they can self-certify. Now, an individual opens an Able Now account, and you're probably wondering, what can we use these funds for? The money in an Able account can be used at any time to pay for a qualified disability expense, and an expense is qualified if the expense was incurred at the time the individual was considered an eligible individual. The expense relates to their disability, and the expense helps to maintain their health, independence, and quality of life. The examples that you see here are purposely designed to be very broad because every individual is going to have a different need with their Able Now account. A lot of our account holders use the funds for basic day-to-day living expenses, food, clothing, groceries, transportation's another big one, housing, education and training. With the mention of education and training, I do also want to note that currently 529 funds can be rolled over to an Able account without any tax penalty. So maybe an individual had a 529 account, but maybe an Able Now account will better suit them. You can roll those funds over. We do have information on that on our website. We at Able Now do not require any receipts or proof or documentation of what you're using the funds for, but we highly recommend that customers keep records and receipts of how they're spending their money in their Able Now account. And there's also an Able Now debit card attached to the account. It's a Visa debit card and can be used wherever Visa is accepted. So what are the advantages of saving in an Able Now account? That main one is, of course, save beyond those asset limitations. So I have some really important numbers to kind of put out there. So keep in mind, generally funds saved in an Able Now account are disregarded when determining eligibility for certain means tested benefit programs like SSI, and Medicaid. If an individual is receiving SSI, their account balance can grow up to and including $100,000. Once they exceed $100,000, that amount over could be considered an asset and may cause those SSI benefits to be reduced or suspended. There's no impact on Medicaid benefits, regardless of how much money is in the Able Now account. And I also want to mention that back in 2020, Virginia passed some legislation that got rid of that Medicaid clawback provision when it comes to Able savings accounts. The other benefit is you can save with the help of others. So anyone can make a contribution to an Able Now account. You can also set up direct deposits. So maybe they want to have their Social Security income go to their Able Now account or other recurring payments. They can again have that go directly into their account with that direct deposit feature. Save in an account designed for your unique needs. Able accounts are designed to be flexible and low cost to maintain, and you can manage your account anytime, anywhere with an accessible online tool and actually a mobile app. And then lastly, you can pay for those qualified expenses with the Able Now card. And then lastly, you could save tax-free. So you heard me mention that Able Now accounts are tax advantage savings accounts. So earnings on investments will actually grow tax-free at the state and federal level. And you'll never be taxed when you're using the funds for a qualified disability expense. Able Now contributions may qualify for the Savers tax credit as well if the account holder is eligible. And then also for Virginians, there is also a state tax deduction benefit where they can deduct up to $2,000 per year for contributions to an Able Now account. And I know I'm getting close on time, so I think I just have like 2 more slides. So very quickly, there are some investment options with the Able Now program. And very simply, how that works is the first $2,000 are automatically deposited into an FDIC short deposit account, which is linked to your Able Now card. And then once you exceed that $2,000, you can decide to invest your funds. But again, this is optional, and we do have a lot of great resources on our website that talk about the investment options. I do want to talk about the account cost. So there's no enrollment fee and no minimum contribution. There is an account service fee of $3.25 per month, and that is waived if you maintain a balance of $10,000 in that deposit account. And then there are some asset-based fees depending on the investment portfolio if you were to decide to invest those funds. ablenow.com is how you establish the account. And then I do want to touch on who can open an account or how those accounts are established. If the eligible individual is over the age of 18, they may open and manage an Able Now account independently, so they're an eligible individual. But if the individual is under the age of 18, unable to open the account, or chooses not to exercise signature authority, they can actually have someone open the account and act on their behalf. And this is going to be called an authorized representative. And I'll leave it here and just mention, the different types of authorized representatives. So you can have an eligible family member open and manage that account. That's going to be a parent, spouse, sibling, or grandparent. Or maybe you have a power of attorney or legal guardian or care representative. They can also open and manage accounts as authorized representatives as well. Just keep in mind, if you fall in that category, you will have to submit the appropriate legal documentation, but don't worry, we will let you know what forms are needed or what information is needed. We also have the option where rep payees and organizational rep payees can open and manage accounts as well. And then again, this is our customer service information, our website, ablenow.com, or you can call if you have questions. Myself and our program manager, Elisa, are both on the call. So if there are questions, we will be more than happy to answer.
Thank you, Brittany. We do have a couple of questions that came into the chat. The first question is, the 529 rollover option was set to expire. Has it been extended?
They're currently working to extend that. So I think there has been some progress either on the state or House side on the federal level. So we are hoping that will be extended or made a permanent provision. So I think essentially what our government relations team and what our team has been encouraging families to do is, if they are looking to do that, to get that done as soon as they possibly can, just in case that is not, in case they don't extend that provision. Good question.
Okay. The next question, do you have to report the ABLE account to Social Security?
So I have heard where individuals have had to have a letter created just stating that they have an Able Now account. And I do believe our customer service team has a letter that they can generate, and so that can be sent out to notify them that they do have an Able Now account.
Okay, wonderful. And what are the qualifying expenses for an ABLE account?
Yeah, so really the key thing is that expense going towards maintaining health, independence, and quality of life? And if it falls under that category, it's going to be considered a qualified disability expense. A lot of families want to have like a guaranteed list, and unfortunately, the programs, we don't even have a guaranteed list, because every individual is going to use that account in a different way. So again, the key thing to really consider is it going towards maintaining their health, their independence, and their quality of life? And you would be able to use the Able Now funds to cover those expenses. We have had family, individuals take vacations. That's a quality of life expense. So I know I had that slide in there that kind of touched on a few categories, but you really just want to make sure that it's kind of falling under one of those three categories that I mentioned.
So that's a very good point. There's a follow-up question. Does the eligible financial management expenses include life insurance premiums? So are the premiums an eligible expense?
That is a great question. Elisa, I know you're on the call. If you could put in the chat, that's the first time I've heard that question about the life insurance premiums. We've had some other life insurance questions kind of come up. But Elisa, if you're on the chat, if you're able to maybe drop that in the chat. If not, we can definitely look into that and follow up with the individual who asked that question. I will say that I know that like legal expenses are covered and other financial expenses as well. So we get a lot of questions about special needs trust and can those be, can able funds be used for special needs trust or to set up different things like that? And the answer is yes. So, but yeah, we can definitely follow up on that other question.
Okay, fantastic. We have another question. If a disability person is a small business owner, how it can have ABLE account, or will that impact on the small business owner?
It should not impact them being a small business owner. One of our old advocates is actually a small business owner. And I don't know if I want to, if I can name drop here, but he actually has an ABLE account and, puts funds in his ABLE account, and we converse often, and it should not impact their small business. Keep in mind, ABLE accounts are asset protection. So we do get a lot of questions about if an individual opens an ABLE account, can they work more? Can they earn more? And it does not impact those things, or, won't change those things. ABLE accounts are what we call asset protection.
Okay, very good. And then is there a list of financial management expenses available on the ABLE account, on the ABLE website, I should say?
So are they looking for like a list of what they can use the funds for, or like examples? Yes. Okay, so we have that kind of generic list that I shared in the slide deck. So again, the federal legislation doesn't even have a complete list that states can kind of abide by. So really the key thing you want to make sure is it maintaining their health, independence, quality of life? If you ever have like kind of a if you're not sure about something, you can always reach out to our customer service team, and they'll be more than happy to kind of get that answer for you.
Okay, we have another question.
One of my time, Christine, for just these last two.
Okay, very good. I know there's been several. So one of my adult children received a diagnosis of PDD, NOS, and dyslexia and dysgraphia as a child. PDD, NOS has since been wrapped up into the autism spectrum, but her medical history does not reflect an autism diagnosis. Does she qualify for an ABLE account with a PDD, NOS diagnosis? Also, does an adult who had this diagnosis of a developmental delay qualify?
So we do have adults that do qualify. The key thing right now is you want to make sure the onset of the disability occurred prior to age 26. As far as the specific diagnosis, the rule is if that diagnosis will have I believe it's a impact on their life for at least 12 consecutive months. There is and I can see if there is the Social Security like PALMS out there that has a little additional information. So that may be something that they may need to check out. Unfortunately, we aren't the ones who can like say yes or no to a certain diagnosis. And so if in that case, they may need to check out that Social Security PALMS, or that may just be something they may need to reach out to our office or our program manager just to kind of see if they do qualify or fall under that qualification.
Okay, wonderful. One last one. Is the 529 to ABLE rollover limited by $18,000 per year?
Yes, correct. So if you're rolling funds over from a 529 account, you do still have to abide by that annual contribution limit. So if you have more than the 18,000 in the account, you would only be able to roll over the 18,000 for the year.
Okay, fantastic. Thank you very much.
You're very welcome. Thank you.
Thank you so much, Brittany. And we want to acknowledge Alyssa Ferguson, the program director who is also on the line, and she asked her to place her response in the chat because she, like Christine and I, are all struggling with our voices today. And so thank you so much, Alyssa Ferguson, for having Brittany pinch hit for you today. Lots of questions have come up. Brittany, if you could give your website one more time so that they can follow up or even place your email in the chat for those who have additional questions and may want to follow up with you guys. Could you do that for us, please?
Absolutely, yes. Thank you.
Thank you. At this time, we would like to turn it over to Kristen Carlton and Dr. Kathy Matthews, who are co-presenters representing all needs planning. Kristen, take it away.
All right. Thank you so much, Dr. Penny. And I was saying earlier, this feels like the old days of doing PIP. So it's great to be back. And it's really an honor to be here and a welcome time where we can share this space with like-minded individuals who are all looking out for creating better community and better resources for people with disabilities. So thank you. We're going to be talking today about how to support your family with disability planning. And so the first thing I'll tell you is I learned about this through my son, who I learned about his diagnosis when I was 19 weeks pregnant. And some people find out about developmental disabilities later. He was in the womb for me. And so it immediately got me thinking to, like, what are the milestones that he's going to go through? And what is his life going to look like? And how do we prepare for it? How do we plan for it? And if you look at this slide and think about this, the milestones and the stages really do look different for our families, and they will look different for my son. And so, you know, I was one of those crazy people who was trying to plan as much as I could before he was born, like calling early intervention and scheduling meetings. And people were telling me, like, hold off, you know, he does have to be born to do this. But that being said, the planning helped give me a sense of control, and it helped me in what was a very, very anxiety-provoking time to put some things on paper and know that I could do some things to help guide and navigate our family through the path. And so think about where you are on this spectrum, and then think about that in that stage as we talk through the different resources that are available. I'll also say language is really, really important to our community, and there are a lot of different ways that people speak about the disability community, and there's a lot of different thoughts of, you know, do we use person first language? Do we use disability first language? What's the preference? There's a lot of strong thoughts about and feelings about the word special needs. When we are meeting with people one-on-one, we have the ability to ask and pay attention, close attention to what their preference is. But in this forum, we don't have that. And so please know that it is really important to us that you feel valued and cared for, and we are doing the best that we can. As we talk about the disability planning process, I want you to think about what it takes to care for yourself, for your loved one, for your family, in terms of financial and support plans, in terms of benefit strategies and benefits eligibility, what's available on that day-to-day basis, and then what's needed to protect your family, the tax, legal, and insurance protections that might be needed. And then for GROW, there are many people, I think, that come to this thinking that in doing planning, we're going to create a box and you have to fit into the box. And that's not at all what we're trying to do. What we want to do is build a framework that provides support on the bottom, right, for when you need it, but allows you to grow into your full potential and your kids to grow into their full potential. And so it's really important that planning is flexible and that it's person-centered and family-centered, accommodating all of your needs and goals and wishes. So, and I do feel like this needs to be said as well when we're talking about disability planning and we have someone who is benefits eligible, meaning they're receiving some kind of a Social Security or supplemental security income benefit, Medicaid and or a Medicaid waiver, that planning is about giving them the best life possible and also protecting their benefits eligibility. Sometimes it feels like those are at odds. And so trying to address that friction and take away as much of the friction as possible to keep your goals and plans front and center in all of the planning is really important.
So I'll introduce the Smith family as our example. So like Kristen, I'm really here as someone who wants to focus and hone in on the strategy around disability planning. I spent my professional years working in nonprofits, helping individuals and families with disabilities. And it wasn't until about 15 years into my work that I then had my own child with a disability and have had since then had another child with a disability. So I came into this space professionally and have since also become a parent. And I value all of that expertise and bring that together. But when I met Kristen and she said, hey, there's this problem with planning, like where are the services and how does this all get mapped out for families? I thought, yeah, you're right. So we're gonna help kind of explain the strategy behind it by going through this particular family. So I can dive into the care plan. So what we want to do when Kristen mentioned that strategy is care, protect, and grow all coming together. The care part is really first thinking about the care plan. How do we take care of our day-to-day and how do we capture what it is that we're doing during the day? You know, if I suddenly wasn't here and you came over to my house to support my two little guys, what are you doing? How do you know what kind of help they need? So how do we take all of that really expert information out of our heads, out of our day-to-day, really reflect on that and pour that into a document that we then can share with the people that are providing supports to us, our families, and we'll talk a little bit more later about a microboard and how that fits in. Another part of that is thinking about the cost of care. So there might be things I do every day. Is the person stepping into my shoes or the support need, can that be provided by anybody, or does it require somebody with some professional expertise such as nursing or medical? I think about some of the things that our families do to support their loved one that really, if it wasn't them, it really would be more of perhaps a medical expert or an occupational therapist. So as parents, we're often, we're learning to do all the things and we're providing a ton of support, but who would step into our shoes? So that's all about taking that moment and why we start with the care plan to think about what's happening, who does it, and what does that look like. But then, as Kristen said, we want to look at benefits and eligibility, making sure we're looking at access to Social Security or supplemental income, going through that disability determination. There's actually strategy and information about starting that at age 18 during those years where diagnostic information, assessments, and documentation about disability is really fresh and available. As well as the Medicaid waiver. Certainly here in Virginia, the developmental disability Medicaid waiver is waitlisted here in Virginia, whereas that CCC plus waiver through social services is not. But there are different qualifications for each of those waivers, but they both still adhere to that asset limit that we've been talking about today. So we want to help and think about, do we meet eligibility? what role does this benefit play in life? So Social Security being that income, a waiver, services. We want to make sure we've covered all of that in care. And then the financial plan is really driven by the cost of care. So we actually have a tool, and we want you to think about, whether using our tool or your own, what is the cost? So maybe right now I'm making a doctor's appointment and I'm providing transportation and I'm helping and assisting with the doctor's appointment. But if I'm not here, who's making that appointment? Who's providing the transportation? And who's assisting with the doctor's appointment? So there's so many things that we do on a day-to-day basis that are unpaid supports that need to be captured through that financial plan and that lifetime cost of care. And as you just heard, with the ABLE account and other mechanisms and tools that can be used as part of that financial plan to not only track and plan for the lifetime of the individual with a disability, and also your lifetime. You know, I have to think about funding that's going to get me to retirement, and then funding that's here when I'm not here to support my sons.
So as we're thinking through care and we're thinking through the different ways that somebody can pay. So every person, every human, right, needs some way to generate income for themselves and to pay for their expenses. And so think through the different ways that you can do that. You can work, right? You can work yourself, or you can have other family members who are working to support you. You can have investments that support that, right? And those investments could be in an ABLE account. There's a lot of different ways to save and have investments. There's government benefits that can provide that. As Kathy mentioned, the supplemental security income, SSDI, Social Security disability income, understanding that disabled adult child benefit, also Medicaid and Medicaid waivers. You can lower tax liabilities, have a really good understanding of tax efficiency. If you're paying lower tax, you can increase your income. And you can have life insurance and proceeds from life insurance. So just understanding those different aspects of it and which ones you have available to you is a really important part of your plan.
This is an example of how to determine that cost of care. So you can look at different categories of care. So housing, food, personal needs, recreational activities, continuing education, work, transportation. There are lots of different ways to think about what are the kinds of things and activities I spend money on. And then we can go in and say, well, what am I currently spending? What am I currently paying for this particular service or activity? What do I expect to continue to pay? Does that cost change at all if I have something like the Medicaid waiver? Or does it, maybe if I don't have the waiver, what does that cost look like? And a little place for notes there. So it's great to go through an exercise like this and think about all the different activities. You know, I love to talk to individuals and families about, take me through the time you get up in the morning till the time you go to bed, weekday, weekend, and we start to plug in, you can see on here, you know, McDonald's, you know, just all kinds of special foods, you know, utilities, maintenance, and this, if we could show you the whole document, would be pages and pages long. But it helps you to understand, if you look up there in the box, what is a current monthly expense? What is that expected expense? What happens if the waiver isn't there to provide some of those services? Because again, when I just mentioned, if I'm the person that makes the appointment, drives to the appointment, and stays at the appointment, that is something, if you have the Medicaid waiver and you're getting some services through that, that could provide some support in those areas. So if I don't have the waiver and I'm not here, someone else, there is going to be a cost to paying for someone to step in. So the point of doing an exercise like this is to get a sense of, what are the monthly costs? Let me calculate that out across your lifetime. Like, what if you imagine knowing, okay, I cost $4,000 a month and I'm going to live X many more years. You start to come up with a number, and then you can backtrack and say, well, how do I meet that cost of care? How do I start to plug in? Is that Social Security, some of those funds that can cover some of those expenses? is that where a special needs trust can provide, something I need to work toward to have in place and ready when I'm no longer here? Is that life insurance? Are there different tools to cover those costs?
So I'm not going to talk too much about the ABLE account because Brittany did such a great job of giving us so much information. But I did want to show you in terms of the example and in terms of how you can use an ABLE account. If you see the ABLE here, in my opinion, the ABLE is the best instrument to give someone who needs to protect their benefits eligibility financial independence. So it gives you autonomy, you have access to your own funds, you can have a debit card that's in your name that you use, and you don't have to ask permission from a trustee to access those funds. They're yours to use. So I love that with an ABLE account, and you can set this up so that a special needs trust has instructions to fund the ABLE account annually. So that's really important as well. So when you think about that, a trustee has decision-making power over all of the assets that are inside the special needs trust. So there is a barrier between the special needs trust and the person with an individual. What that means in real life is the person with a disability has to go and request money from the trustee. And then the trustee has the power to say yes or no based on their duties as trustee. And with the ABLE account, that requirement is not there. So the person with a disability can access that money directly. So that's really the reason I'm so passionate about the ABLE account.
Going back to the care portion, again, just to summarize that, when you're putting together the financial plan component, summarizing this to say, do you know the cost of care for your loved one? Have you gone through that exercise? Or you as an individual, what are those costs? So that's the big first step. As a parent or caregiver providing support, how much are you going to need during your lifetime? So we always want to think about, sometimes when we're planning as caregivers or parents, we're planning for 2 lifetimes. Do you have any other goals that need funding? And then are there any gaps? Are you seeing a potential gap in those funding streams in that financial plan that need to be addressed? In terms of looking at benefits, so this is something you want to consider whether or not this is going to apply to you. It's always a very individualized decision. So Social Security offers a lot of different programs. So the ones that we really highlight, supplemental security income. So that's where someone is not making enough income or have that income in place to meet their needs. So you can do an application and get those funds going. Social Security disability income is what we call SSDI. And so what's great there about SSDI is that it's also going to give you access to Medicare eventually as well. So those combined benefits. And then the disabled adult child is when we as caregivers are plugging into our own Social Security retirement, that is an added Social Security benefit to our loved one who is already receiving those Social Security funds. So again, when we think about or talk about doing disability life planning, this is all really very strategic. So a caregiver's decision about when to retire and collect their own Social Security is going to have an impact could have an impact on their loved ones' Social Security income. So we want to think about the disabled adult child benefit. So a lot of this is just thinking about what is the right strategy or way to go about this. Traditional Medicaid. So that is health insurance. What's great there, because we'll have families or individuals, I'll hear folks say, well, I don't need Medicaid because I'm on mom and dad's health insurance. You need to be Medicaid eligible in order to receive the Medicaid waiver. And when you do have that Medicaid health insurance, what's great is that it does operate as a secondary insurance. So it's going to collect those things that likely your primary insurance carrier has not. And then again, as I mentioned, a couple of other benefits that we look into are the waivers. And again, sometimes I'll hear folks say, well, there's no point in applying because the wait list is so long. Again, this is a very individualized decision, but what the waivers do that's so great is they provide services and an array of services, from in-home supports, respite, residential supports, day programs. And the other piece there that's really important is a lot of the providers that provide residential, day, in-home, all those services, they require the Medicaid waiver. So it's something where sometimes when families or individuals don't have a Medicaid waiver there, they don't have access to some of these great resources and programs that are out there. So if we need those services, we want to think about applying, and there are different requirements between that CCC plus through social services, which is going to look at more medical and disability needs, and then the developmental disabilities waivers through home and community-based supports, which are going to look at, provide the residential and other developmental services. So coming back to that example of Sam and his family, so we had Sam there and his parents, and putting together their care plan to just help you see how all of that would come together, is that Sam's parents went ahead, because they're doing so much right now at this time. Sam's parents are providing transportation, they're providing assistance to him and daily support. So they went ahead and wrote down all of his care needs to get them out of their heads, put them into a document that could be shared with others. Jana realized as mom, she was providing a lot of unpaid supports to him, which includes clipping his nails, cutting his hair, all of that. So she really wanted to make sure that she thought about how those services were going to be provided in her absence. Sam went through that disability determination with Social Security, and so he is going to be eligible for that, including the disabled adult child benefit. So that means that he's getting Social Security based on his record, based on his parents' record with that disabled adult child benefit. He's also applied for the Medicaid waiver. So even though he's not on the waiver yet, he is on the wait list, which means he's in line. And another thing to know is the waiver is really responsive. So if something were to happen to his parents or someone's ill or less able to work, that waiver would up his priority level, and there could be some advocacy in place to help him access those waiver services more quickly. And that is something, when I just said advocacy, when you're on that waiver wait list and you need it, you need to be communicating with your waiver case manager, as things change in the home. If a parent isn't working, if more supports are needed, if there are medication changes, make sure you're really staying in touch with your case manager so that they know, here in Virginia, through that developmental disability waiver, that priority status is going to can improve for you and increase your ability to get on the waiver as your situation at home changes. And then certainly now Sam's parents, they have a plan in place. So the waiver, when they were looking at those costs of care, is now going to be able to step in ultimately when he receives it and provide some of those services that he needs. The Social Security funding coming in is going to give him the funds that he needs to pay for some of his own daily costs. And this is all moving towards Sam being more independent in the future.
So once we've gone through the care part of the process and you're thinking about your family with the financial plan, the government benefits eligibility, and addressing any gaps that might be there, the next step is to look at how to protect your family. And the tools that we look at most commonly in how to protect your family, there's insurance and understanding what types of insurance there are and how you might use them. There's tax protections and really understanding how tax laws might impact you. And then there's legal protections, and that's estate planning for mom and dad, but it's also decision-making supports. And so we're going to look at insurance, how you can use insurance as a tool to address gaps that are uncovered in your financial plan, and also talk about risks. So the reality is every family faces risk of premature loss of income and loss of life. But when you have a family that's experiencing disability, that risk can be catastrophic. And so understanding that and looking at the right tools to address it can be really important. Remember unpaid labor when you're looking at this. And permanent insurance is important, and I'll put that here, but not always necessary. So, and we'll talk about that. In terms of tax, I want to just tell you, many people don't realize that many medical expenses people are not taking as deductions that really could be taken. Think about if you're traveling to a conference, a medical conference, those expenses are considered medical expenses. If you're traveling to specialists, so my family, we travel to specialists up in Baltimore several times a year. If you're paying tuition for a private school that is medically necessary, that could be a medical deduction. Remodels. So if you're doing certain things that address accessibility needs that don't add value to your house, that could be a deduction on your taxes. So please know all of those things. We're not CPAs, but they're definitely things to run by a CPA and get information on. Estate taxes and IRAs, retirement accounts, the Secure Act, if you've heard of that, it allows somebody with a disability to inherit an IRA and then stretch the required minimum distributions over their entire life. But there's specific language that needs to be addressed if it's going into a special needs trust. And that if that specific language is not in there, that stretch goes away. And so thinking through what's the right vehicle to go into a retirement, to go into that special needs trust, right? Is it a retirement account? Is it something else that's within your investments? Thinking through all of those things can be really, really important from a tax standpoint. And then from legal, I'm really not going to go into too much of this because Nick is going to cover that in depth for you. I will say we do try to build a robust legal strategy with our families, with your loved one in the center, that addresses decision-making support, the parents' needs through their trusts and wills and power of attorneys and medical directives and the special needs trust. And then Kathy's going to talk to you a little more about a microboard.
Yes, we see microboards as, we often call them the silver bullet, just such a great strategy when we think about that lifelong support and advocacy for someone. So it's really a formal circle of support where we're going to pull together, just like a nonprofit board, a board of directors, a board of folks that are committing to providing ongoing advocacy and support to an individual with a disability. So micro refers to the fact that the board is there for the benefit of one person. So they're not there to make decisions for an individual with a disability. They're not there to restrict anything. They're really there as advocates and to provide guidance. Here in Virginia, you can register your microboard as a non-stock corporation. And so there is an annual fee to keep that registered. But we think that the formalness of it, the fact that it's registered and that it has articles of incorporation and bylaws is so important when we think about who's going to be here to provide support. If we can put together a team, I think of all the people who have said, hey, let me know if you need anything, or, friends. Some of us think, well, I know someone who's great, but I wouldn't ask them to do too much to provide support. But could they sit on a board? Could they go to a board meeting a couple of times a year and really hear all the details of care that are needed? This is where that care plan we initially talked about, this would be introduced to the microboard so that they could really learn the kinds of things that you know about the individual that you're supporting. Just to give you an example, I talked to a member of a microboard that we're supporting, just as an example. And when I first helped this family set up their microboard, we're talking about, they were two neighbors, a nephew and his wife. They were folks that all knew the individual with a disability, but weren't really providing any support to them. But over the course of a year of meetings and reviewing the care plan and support needs, they're now coming together and doing things like putting together a respite plan when mom is out of town. They're working through communicating with the Medicaid waiver service providers that are supporting this individual. So they went from not really knowing anything or what to do to knowing what to do. So the bylaws really help people organize, right? When you're on a board, you're trained and you're like, okay, I know how to help. And that's a great way to orient someone who cares and is a great person, wants to help but doesn't know how. So they can come together and really provide advocacy to the in support of the individual with a disability, but also in support of you as a caregiver is tremendously helpful. We've also seen them help siblings who are there and wanting to provide some additional support, maybe in place of their parents, but again, not totally knowing how. So if you want to go to the next slide, I think, Kristen.
Sure.
This is a big part of that ongoing protection, those microboards.
So as we continue to think about protections and we think about insurance, think about the types of insurance. And I mentioned that permanent insurance can be important. I want you to know there is term insurance, which says, hey, we're going to give you this insurance for a certain period of time. And for that period of time, that term, you pay a specific price and you don't have to go through medical underwriting to keep this insurance. At the end of that term, they may not require medical underwriting to provide the insurance, but then they can charge you whatever they want. Permanent insurance says you go through underwriting at a certain period of time, medical underwriting, where they're saying, hey, you're medically eligible for this insurance and we'll give it to you at this price. Permanent insurance says you never have to go through it again. It's guaranteed to stay in place for your whole life, so permanently, as long as you pay an agreed upon amount. Now, there are very different types within that, but that's basically the difference between term insurance and permanent insurance. But then there's something called convertible term. And we see a lot of our families using that. That says you start with a term, but there's this option that you pay a little bit extra for that's called a convertible rider that says at any point during that term, you can convert that term policy to permanent insurance without medical underwriting. And we find that's the right solution for a lot of our families because it's less expensive than permanent. And if they end up not needing it, they can let it fall away. But if they end up where they do have a need for permanent insurance, they can use that convertible rider to convert it. There's also something you should know about called survivorship life insurance, where you would have two people, generally spouses, where the survivorship says upon the death of the last person, the last survivor, this money, this insurance gets paid to your beneficiary. And that survivorship insurance is generally also less expensive and does what it's supposed to do, right? It's leaving money for the dependent with a disability. There's also long-term care insurance, which I'm sure you've heard of, which can be on an individual, again, who goes through medical underwriting to pay for long-term care when needed in their life. And so when you think of those different types of insurance and how you might use them, there's always the principle of you can pay for something yourself, right? You can pay for it yourself or from your estate, or you can pay for it with insurance. And so just think about which path is right for you and your family. The items that you might need to protect, the lifetime cost of care for your loved one. Somebody becoming disabled who's working and now no longer able to work, premature death of a caregiver or a wage earner or both, and the ability to pass on an estate and pay for long-term care expenses. So those are things that we talk about, we hear from families all the time that they're worried about. that life insurance might be a good tool.
Kristen,
Yes.
we're running out of time, so I want to make sure that we get to some of the questions. And
Absolutely.
we need to shift to that third presenter. So can you wrap this up, or are you ready to take questions?
Let me just say really quick that I want people to not forget about their own personal growth and planning and taking time for themselves in this process, for every member of the family. And we talk a lot about person-centered planning. I want to make sure that every member of the family has that. And I just want to make sure that everyone is thinking about growth and how that pertains to their family. I'm going to go to, let's see, just some resources for you all. We heard from ABLE. There's abletoday.org is another great resource on top of ABLE Now. And for waiver information, which we touched on today as well, there's My Life, My Community from DBHDS. They have a great website that gives you a lot of information on waivers. PTSI, huge fan of PTSI. They provide a lot of education across a lot of different topics, including waivers, Social Security, and IEPs and advocacy. For Social Security information and advocacy, I encourage you to look at the Ticket to Work program. And VCU has a lot of information about that through various different programs. Ron Conkle is also a Social Security advocate that we've worked with quite a bit. IEP advocacy, PTSI can give a lot of education. Medical Home Plus can actually give you advice specific to your family. And the Arc of Virginia, if you're here, you know about the Arc of Virginia, I'm sure. The Arc of Northern Virginia has a pooled trust as well as Commonwealth Community Trust. And then we are with All Needs Planning. We have a free special needs master class on our website that you could go to and get a lot of information and a framework for building this plan for your family. So that is it, Dr. Penny. Thank you so much.
You're welcome. I want to turn it over to Christine in just a second, but there is a question that came for transparency purposes. Is All Needs Planning chartered as a nonprofit, a not-for-profit, or a profit-making organization? And then the B part of that question was, how was All Needs Planning selected for this webinar? I want to answer the second part of that question by sharing that our training alumni meets annually in a retreat, and together they identify what they believe are very, very important topics that need to be addressed, that are affecting or where persons with disabilities need to be educated or trained. And from that, there are recommendations for various presenters from around the country, including, of course, here in the Commonwealth. And so we, in my unit, solicit all kinds of presenters to come. We look for expert presenters. I would say, and I think that my executive director would agree, that it is important for us to say that Virginia Board for People with Disabilities does not endorse any individual, any business, any for-profit, non-profit, or profit-making organization. We simply are bringing, on behalf of the training alumni, graduates of the Partners in Policymaking Training Program and the Youth Leadership Academy, alumni who have said, we need information on this, and we seek to invite experts in these areas. Let me have you and yield to you, Kristen, to respond to what type of organization you are.
Absolutely. So we are registered as an LLC. So we are a for-profit organization. When we formed our company, we're a team of moms who have kids with disabilities. We really looked long and hard about how we would structure it and why we would do it that way. And the biggest thing we said is we're building this for our families and for families just like ours. And we want it to be a sustainable model. And we saw in building this type of support that one of the best ways to build a sustainable model was to do it in the for-profit model.
Okay, thank you. We have a few questions, so let's get at it, Christine, real quickly. Let's see how many we can get to.
Absolutely. So the first question, how do they register for the micro board? Is there information or a website about creating a micro board?
We have, so there's not a direct website to find out about the micro board. We certainly have some information, definitely in the master class that we provide to families. We'd be happy to, we do have a set of bylaws, sample bylaws and articles of incorporation that we'd be happy to share with folks if they would like that. But it's something that, because each state does it differently, there's not right now a central source, but we're happy to provide those resources.
Okay, fantastic.
Yeah.
The next question is, I work with an individual who has an autism diagnosis, but SSA denied benefits due to family financial support, was not Medicaid eligible. Could she still utilize or benefit from an ABLE account?
Yes, the answer is yes. She could still utilize and benefit from an ABLE account.
Okay, wonderful. And then we had somebody make a comment that on Medicaid and on the waiver, Medicaid provides transportation.
Yes.
So they are a community engagement program, and nearly all of the individuals are transported to and from their program.
Yes, it's a wonderful part of Medicaid, which is why we definitely encourage folks to look into that, see if you're eligible, and that makes sense.
Okay, and then one more question. What are the legal parental responsibilities for caring for an adult child with a disability in Virginia? Divorced parents, one is a sole caregiver, and the other has asserted that the child is now an adult and that their parenting responsibilities are done.
Maybe we can shift that to Nick
It
Thompson.
might be for our next presenter.
Yes, I think that is
Yes,
a
and
better question for Nick.
it's about time, if you don't mind. It's about 1:10. We're trying very hard to finish on time, and we thank all of our participants for your great questions. We would ask the same if you would drop your contact information. I hope that everyone has taken a picture of the resources that they gave us, because there's so many other avenues in which you can get this information. Let me now turn it over to Attorney Nick Thompson, who is the adjunct professor of law at William and Mary Law School, the managing attorney, elder and disability law clinic. Attorney Thompson.
Thank you. Thank you. Good afternoon, everybody. And yes, Christine, please do bring up that question when we get to the questions for my section. It's a relevant one. I think what we heard at the end there from Kristen is really important. We're really here to share resources and information with parents and loved ones. And so we want to make sure that you all have the resources that you need to, live your most and best life. A couple that come to mind, I didn't put them on slides because I didn't think to share them, but as was mentioned, I run the William and Mary Elder and Disability Law Clinic. So I'd like to think we could be a good resource for you. At William and Mary, we have other clinics that can be helpful. We have an immigration law clinic. We have a family law clinic. We have a special education clinic. So to the extent that you want to reach out to any of those for some specific needs, please feel free to do so. Additionally, your local legal aid societies in Tidewater area, that's Legal Aid Society of Eastern Virginia. In Central Virginia, that's the Central Virginia Legal Aid Society. There's also Southwest Legal Aid Society, and then there's one for Northern Virginia. So to the extent you have legal needs, you're more than welcome to reach out to me or to any of those organizations. I'm sure they'd be happy to put you in contact with someone who can help you. I'll leave this first slide up here for a little bit. That's my contact information, my personal email, my cell phone. You're more than welcome to reach out to me with any questions that you have from my presentation. Given the 30 minutes, it's hard to cover everything, especially everything in enough detail that it deserves. So I'm sure there will be additional questions, even questions that get asked that I don't get to. Please feel free to shoot me an email or or give me a call. I'll be happy to chat. But today we're going to be walking through estate planning as well as decision-making alternatives. The slide here shows kind of at a high level, we'll be talking about wills and special needs trusts, advanced medical directives, power of attorneys, and then ultimately guardianship and conservatorship. And with that, we will dive in. You may notice it's a little technical, it's a little legal heavy. That's because that's what these are all about. That they're all about the law, and I can't stress enough the importance of making sure you're receiving good legal advice. So always consult an attorney. All right, so at first, talk a few about definitions that will help us as we're thinking about wills. First is the word decedent, right? This is the person that passes away, and this is what the law of wills is all about. We want to figure out what's going to happen to their property, what they want to happen to their property, most importantly. If someone dies with a will that covers all of their property, that's called dying testate. And then if somebody doesn't have a will or their will doesn't cover all of their property, that's intestate. And so it's important to think that, or remember that not all property passes via a will, right? Your personal property will, but what about jointly titled assets, right? The most common one is a home. You might own your home jointly with the right of survivorship with your spouse. Likewise, you might own a vehicle with someone with the right of survivorship. And so those assets would not pass under a will. They would just pass by what we call operation of law. Second group of assets that don't pass under a will are assets that pass under a different type of written instrument. For example, we talked about life insurance earlier. So life insurance is a good example of an asset that will pass to a beneficiary regardless of what a will says. So it's always important to, as you're evaluating your estate plan every couple of years or every time there's a major life event, to evaluate who you have listed for your beneficiaries under those assets that pass outside of a will. All right. Why would somebody want to have a will? What does a will do? Well, first of all, it lets the person who's signing the will name who they want to receive their stuff, right? They get to name their beneficiaries. Second, it lets you name who is supposed to oversee the process of distributing all of your stuff and your property. That person's called an executor. It allows people to give others specific items that they might want them to have, right? Maybe they're leaving everything to their children, but they really want their sister to have this very specific set of earrings that came from their mother. And so you can leave specific items to specific people. This one I always laugh at. Theoretically, it prevents family disputes after death, but there wouldn't be a trusts and estates class in law school if there weren't disputes after someone passed away. And then a final reason might be that you may name somebody to be the guardian of your minor children, should you and their other parent pass away before they reach adulthood. Note that this is different from naming a guardian or an alternative guardian or successor guardian for an adult who's under a guardianship. That takes place, and we'll talk about that in the next section, but under the guardianship process. All right. How do we have a valid will, right? This is always a question. The ones on the right, we won't talk about too much. Those come from legal textbooks. Those are ones where people have handwritten them. They're not notarized, they're not witnessed, but later on people say, hey, look, that's their handwriting. They signed the will. This should be a valid will. We always always will do the attested wills, which are on the left, right? These are in writing. They're signed by the testator. They're witnessed by two people, two competent witnesses who are both present at the same time, and then they're notarized. So these are what we're going for, and kind of how the process typically works. Speak with families, talk to them about generally their estate plan, have them fill out a few forms that give us ideas about how to draft their documents, get them documents to review, make sure they meet everything that they want. All names are spelled correctly. Everything is exactly how they want. And then we set up a time to have them either come into the clinic, or if they're not local to Williamsburg, a lot of people will go to their local bank to have them notarized and witnessed, but send them off with a packet for signing with signing instructions. So that's typically how our process works at the clinic. Question that always comes up Well, what's the capacity to make a will, right? How is somebody able to make a will? Can my 6-year-old let me know how he wants to leave his property? So first, the person has to be 18. That's the first step. Second, they have to have the mental capacity to understand what they're doing, right? So the law calls this understanding, capable of recollecting their property. It's the first one. They have to know what things they have that they're going to leave to people. The law calls the next step the natural objects of their bounty. What this means is their family members. Who are their family members? They have to understand what their debts are. And then they have to know the business about what they're doing, right? So they have to know that, hey, look, I'm making a plan to dispose of my assets at my death, and this is a serious undertaking. This is what I'm doing. It's a big deal. And so if they meet all of those, then they have the capacity to make a will. Question that always comes up, what if I want to change my will? Or what if I want to revoke my will? Well, as long as the person still retains capacity, they have the ability to revoke their will at any time before they die. And this is typically done by writing a new will, right? Maybe they want to change their beneficiaries or change specific items that they're giving to specific people. So typically that's done by writing a new will. But another way that somebody could revoke their will is by a physical act. They can destroy the will, right? They can shred it up. They can throw it in the fire. That's one way to destroy or revoke your will. All right. As I noted earlier, people can change their wills at any time before their death. And just a quick note, the court, when the will gets probated, is going to interpret the will as if it was signed right before the person died. All right. What happens if you die without a will? I mentioned in the definitions, this is called intestacy. So all states have different intestacy rules. These are going to be specific to Virginia, but the states try to make a plan as to how people would like their estate distributed if they didn't have a will. So it tries to approximate your average person, what would they want? And that's what the laws of intestacy do. As the slide notes, these are a default set of rules, and they're going to apply if somebody does not have a will. And it generally, as a note, favors the family of the decedent. All right. These are your Virginia intestacy rules. If somebody passes away with a spouse, everything generally is going to go to the spouse if all of the children are from the marriage, or if they don't have children. If they have children, but the children aren't from the marriage, then the children will receive a portion of it, and the spouse will receive, again, the numbers are on the slide. You're happy to take a look at them, happy to walk through them with folks, but in the interest of time, I know we want to keep moving forward and get through all the slides. If there's no spouse and there's no children, generally parents are the next in line, and then if the parents are not living, siblings. All right, so wills covered. On to special needs trust, another estate planning tool utilized for the benefit of an individual with a disability. What exactly are special needs trusts? Well, it's a legal arrangement. It's a trust that is created to ensure that assets are there and are used to support an individual with a disability without disqualifying them from public benefits. Right, that's the big key, without disqualifying them from public benefits, similar to what we heard in the ABLE account section, right? That's the main goal, allow there to be resources for the individual while allowing them to maintain their public benefits. This question comes up often. Can I just draft my own? Generally, no. You're going to want to seek out an attorney and make sure the attorney should know and have a great form to work with that their special needs trust conform with both federal and state laws. So note, coming from the attorney, hiring an attorney is very important. All right. And as we did with wills, it's important to start out with some definitions. So we have a grantor, right? This is the person who's creating the trust and often contributing the assets to the trust. Sometimes people refer to this as the settlor. You have the trustee. I believe it was either Dr. Matthews or Kristen that referred to a trustee, but this is the person or entity who's responsible for managing the trust, right? They make investment decisions. They make distributions to the beneficiaries. in accordance with the terms of the trust. Beneficiary, similar to the will definition, this is a person who's going to benefit from the assets in the special needs trust. We have remainder beneficiaries. So these are the people who are going to receive any remaining assets in the trust once the beneficiary passes away. And then just a quick definition of pooled trust. I believe Kathy referred to, or sorry, it might have been Kristen referred to the ARC of Northern Virginia, the Commonwealth Community Trust. These are pooled trust. They're managed by nonprofit organizations. But typically when the beneficiary passes away, any remaining funds become property of that nonprofit organization. All right, some things to consider. We heard them talk about what are some financial things to consider. Well, these are what things are we going to consider when setting up a special needs trust? What's the life expectancy of the beneficiary? Do they have a normal life expectancy? Are they going to live to 80, 82? Obviously, none of us know our exact life expectancy, but we have an approximation. Or is it closer to 50? It's something to think about and plan out. How much money do they need to maintain their quality of life that they have, right? Is their average annual spend $40,000? Is it $100,000? It's important to understand what their needs are going to be. Thirdly, how and when should the funds be distributed, right? What kind of discretion are we giving the trustee? It gets to the next point. Should they have control over the trust funds, or should there be a third party that's going to oversee the spending? And then finally, if there are funds remaining in the trust when the beneficiary dies, where should the funds go, right? These are our remainder beneficiaries. All right. Different kinds of special needs trusts. These questions always come up. We have first party and third party, and I'll walk through each. So first party are going to utilize assets that belong to the beneficiary, right? Perhaps they're working and they have an income. Perhaps they inadvertently received an inheritance from a family member. Perhaps they had a personal injury settlement or a life insurance payout. Those funds, can be utilized. They are the beneficiaries, and so they are utilized to set up a first-party special needs trust. Some people call this a self-settled special needs trust because it's set up by the individual themselves. They are irrevocable and generally require Medicaid paybacks once the beneficiary passes away. Third-party special needs trusts, in contrast to first-party, these are generally established by a family member of a loved one with a disability, and they are generally funded by that family member and other family members. They can be both irrevocable or revocable. They may be funded during the life of the grantor or settlor, but they are often generally funded at the death of that individual. Generally, it's the parents setting these up for their children. And the reason why you fund it at death, well, that's because the parents are generally taking care of their children throughout the rest of their life, or at least planning to. And so they don't need to put funds into the trust at present. They're often funded with life insurance or some other, at death bequest. And as a note, there's no Medicaid payback required with these third-party special needs trusts. All right. For what benefits can a special needs trust funds pay? They're generally pretty wholesome. They can pay for educational expenses, entertainment and travel. Big one are trips to Disney. I know that's a popular trip. They can pay for home modifications or other accessibility modifications, medical or dental expenses that aren't covered by insurance, professional care services such as personal care or housekeeping, rehabilitative and other therapy services, and then other transportation and vehicle expenses that aren't covered otherwise. And so sometimes people call these supplemental needs trusts because the point is they're there to supplement the benefits that an individual is already receiving. All right. The next document that we typically do for our clients in the estate planning is an advanced medical directive. It's going to be only one short slide on this and the next one. because we really need to get to the next topic. But these are written directions that are given to a person, to an agent, to make decisions regarding somebody's medical care, regarding their person. Okay, the corollary for this is a guardian, and we'll talk about that next. It can provide for very specific kinds of treatment and requests. They're very customizable as to what kinds of treatments, what kinds of things the agent can do. All right, so that's for the person. And then we have for the finances. This is a power of attorney, sometimes called a durable general power of attorney. These are written directions given to an agent who is there to make decisions with and for an individual. Much like the advanced medical directive, can be very specific, provide for very specific kinds of actions, and can exclude very specific kinds of actions that a person does not want an agent to take. And generally speaking, the capacity to enter into an advanced medical directive and or a power of attorney, someone has to generally be able to understand the nature and consequences of the actions, right? What is the document? What is the document saying? Do I want to give this authority away? And then ultimately to sign a power of attorney or advanced medical directive. All right, so those are two decision-making options. But what about if somebody does not have the capacity to sign a power of attorney or, quickly, some considerations when thinking about this. Who do you want to be your agent or alternate agent? Again, mentioned in the slides, but what powers or authorities do we want to give away? And then when should the document become effective? So the document can be effective immediately, right? You can make the document so that your agent, as soon as they're done signing it, you provide them a copy. They can go ahead and provide that to your bank or your healthcare provider and start taking actions, with and for you immediately. Or you can make them what we call springing, that they're only effective when generally it's two physicians have said that you're incapable of making your own decisions, whether that's for your person or for your finances. Alternatively, if someone does not have the capacity to enter into those agency documents, we have guardianships and conservatorships. These slides are going to be very code heavy, and I'm going to distill it down. This is hopefully brings the importance of an attorney, especially when dealing with this process. I can't tell you how many times I've seen people try to do this on their own here in Virginia, and the courts generally give them the numbers for the legal aid societies that I mentioned at the top, or frankly, a lot of them give them our clinic's phone number as well. So definitely consult an attorney when going through this process. We're going to talk about the code requirements, very important, a little timeline for folks, as well as some common misconceptions. All right. As I have with the last few slides, some important definitions. So annual reports, these are reports that guardians have to file annually. They get filed with the Department of Social Services where the individual lives. They also, once Social Services receives and reviews them, they send them on to the courts where the guardianship order was entered, and the judges review them. There didn't used to be any teeth for courts if somebody failed to file these. But now, if you do not file your reports, the court's going to issue a show cause, and you're going to be subpoenaed to appear in court, and you could be potentially fined if you do not file your reports. All right, conservator. This is a corollary to an agent under a financial power of attorney. This is a person who's appointed to manage somebody's estate or their financial affairs. Guardian, again, this is the corollary to an agent under an advanced medical directive. This is a person who is appointed by a court to make decisions about the personal affairs of an individual. So that includes their support, their care, their health decisions, their therapy decisions, their educational decisions. All right. A couple more definitions. A guardian ad litem, I'm sure people are familiar with this concept. This is an attorney who's appointed. Their job is to investigate the petition and make sure that a guardianship is appropriate, first of all, and second, that the proposed guardian is an appropriate guardian. And then the definition of incapacity. So this is someone who has been deemed to be incapable of receiving and evaluating information, one, to meet the essential requirements for their health, care, safety, or therapeutic needs without the assistance and protection of a guardian, or two, to manage their property or financial affairs without the support of a conservator. Just a note, just because someone has poor judgment does not mean that they need a guardian or conservator. All right. Where did these get filed? These always get asked because my clinic is in Williamsburg and somebody might come to me from Bristol, Virginia. And they're saying, do I have to come to Williamsburg? No, the petition gets filed where the individual lives. So if the individual lives with their parents in Fairfax County, it gets filed in Fairfax County. All right. The next slide we'll talk about, but why is Virginia the right place? The first answer is if they've lived here for 6 months, then it gets filed in a Virginia court. If they've lived there for less than 6 months, but are otherwise here with an intent to remain, have family here, then a Virginia Circuit Court is the appropriate place to file it. When can it be filed? Well, if it's being brought by a parent or guardian, it can be filed at 17 and a half. And if it's not brought by a parent or guardian, it can be brought at any time after an individual has turned 18. All right. These next two slides are going to violate the cardinal rules of slides and that they have so much information. This is because I want to drive home the point that all of this information has to be provided in a petition. And I want to bring attention to two of them. The first one is the third one on here. So we have to include the names and post office addresses of spouse, adult children, parents, and adult siblings. So when I send intake to people and they send it back to me with no relatives listed, it takes longer because I have to then follow up and say, hey, does this person have adult siblings? Are their parents living? So that information is really needed. Again, these slides will be provided to people if you want to look through all of this information. All right. And other things that need to be included on here. We can have a limited guardian request. Maybe the request is for somebody for specifically medication management. That's the big one where I see limited guardian come into play. But all of that information has to be provided to the court. The guardian ad litem reviews it. They do their own investigation, and then they go and meet with the respondent. All right. Once all of that information gets filed and a few other documents with the court, including a medical evaluation report. So this report is prepared by a psychologist, by a physician, or by somebody else who is skilled in the assessment and treatment of the condition. Has to include all this information. Again, a court's going to review this. The guardian ad litem is going to review this, and this is going to be taken as evidence as to whether the person needs a guardian or not. All right. Once all of that's filed, get yourself a case number, then you set a hearing. All right, so the hearing gets set at that circuit court. So again, my example, I said Fairfax County. You get set a hearing in Fairfax County Circuit Court, and then notice gets sent out. So a notice gets mailed. I mentioned all of those adult relatives that have to be included. The notice gets mailed to all of those relatives, and then the guardian ad litem takes a copy of the notice and personally gives it to the respondent. And they meet with their respondent and talk to them and advise them of their rights. And so their rights include if they want their own attorney, they can have their own attorney. If they want to have a jury trial, they can have a jury trial. They can put on their own evidence. They can examine their evaluator, right? So that physician who filled out the medical eval, if they want to bring them in and have them examined, they could. All right, so a court hosts a hearing. Generally, a hearing's supposed to take place within 120 days of the petition being filed, depending on which city or county you live in. That can be generally closer to 4 to 6 weeks on the quicker end of things. But that's why it's important for parents to, be on the ball and to, have everything ready to be filed at 17 and a half, so that when the individual turns 18, there's no gaps in their ability to make decisions with and for their now adult children. All right. If the court, after reviewing the evidence, determines that a guardian is needed, they're going to then appoint a suitable person. Generally, it's the person who's asked for in the petition, right? If that's mom and dad asking that mom and dad be appointed co-guardians, that's who the court's going to appoint, unless there's some issue with why they couldn't be. All right. All right. The court's order of appointment I'll go quickly. So note, a guardian doesn't need to be appointed if there's an advanced medical directive or a conservator, if there is a power of attorney, unless those are not sufficient or the agent is making or taking actions outside of the scope or breaching their duties that they owe the individual. All guardianship orders, and this is going to have a lot of language on this next slide, they have to include this language, and it's really important. It's relatively new to guardianship orders. I think 2020 or 2021 is when this language came into play. But I want to highlight number 2 and number 4. All right, number 2 says a guardian, to the extent possible, has to encourage the incapacitated person to participate in decisions. They have to consider the expressed desires and personal values of an incapacitated person, and they can't restrict that person's ability to communicate with, visit, or interact with somebody with whom they have an established relationship. All right, and number 4, all guardianship orders are subject to petition for restoration or modification. All right, so that's important. And I think I talk about really quickly once we get to the common misconceptions. All right. After they're appointed at the hearing, they're going to go to the clerk's office and they're going to take their oath. They're going to say, I'm going to faithfully uphold my duties. I'm going to act in the best interest of my respondent here. And they're going to receive information from the court, from the clerk, that's going to instruct them about their rights and responsibilities as a guardian. And they're also going to get a copy of the order and a one-page certificate of guardian. And that's what they can provide to healthcare providers, other care providers, therapists, schools, all of that good stuff. All right, timeline. This gets to my last slide. But generally, once I receive documents from a client, I follow up with them with any missing information, and then it gets filed with their local circuit court. Once the court processes the documents and appoints a guardian ad litem, it generally takes, depending on where you live, 4 to 6 weeks to get on their docket. And then at the hearing is when a person is appointed the guardian. Between the filing and the hearing itself, remember I said that notice gets sent out. So the relatives receive a copy of that notice, and the primary healthcare provider receives a copy of the notice that gets mailed out as well. And the guardian ad litem goes and personally visits with the individual. All right. Timeline, or sorry, common misconceptions. First one, I am taking away all of this person's rights. Well, the answer is no, you're not. And in fact, the guardianships are designed so that you can maximize the independence of the individual, but they're there for the assistance and protection of that individual, not from, the parents, but frankly from the world that just might look to take advantage of your loved ones, right? Generally, they do lose the right to own or possess a firearm. I haven't had any instances where somebody's complained about that one yet. Generally, they lose the right to enter into a contract, right? So they can't go and sign a credit card application, right? They can't go and get their own passport and go to France. The other ones that come up are the right to drive and the right to vote. What even is the capacity to vote these days? Generally, if somebody can name the 2 candidates that are running for the election, they can retain their right to vote. The right to drive, we always have the evaluator opine on that. And if they say the individual has the capacity to drive or would have the capacity to drive with the appropriate training, that's not a hard right to retain either. And then the other one that often comes up, the right to get married, that's generally, they can get married with the consent of the guardian. All right. Next misconception, I was told by my child's case manager that I need to start this at 15. It takes a little bit of time, but not that much time. Generally, I tell parents, come to me when your child turns 17. I'll get you the intake documents. You can get them back to me, and that way everything can be ready when they turn 17 and a half to file. The next one, guardianship will fix all of my child's behavior and mental health needs. No, that's not going to happen. It will give you the legal ability to make decisions for them, but otherwise, you're not going to be able to impact their behavior. School and care providers will continue communicating with me after 18. Sometimes they do. It really depends on the provider in the school, but they don't have to. And a lot of times they won't. The parents will be like, wait a second, there was an IEP meeting. I'm like, what? And the school will say, yeah, your kid's 18. you're not entitled to notice of this IEP meeting. The next one, the state will take my child away if I don't have guardianship at 18. No, they won't. There will just be a period of time where your child makes all of their own decisions. I'm already my parents or my adult child's guardian because I'm their parent. No, you're not. You're minor children's guardian. But once an individual turns 18, they're their own guardian, unless a court has entered a guardianship order. Aren't they impossible to terminate? Tried to answer that on the previous slide. No, they're not. If the circumstances warrant terminating a guardianship, I've had plenty of them terminated. It's not hard, but the circumstances have to warrant doing so. This kind of gets back to the first one. I can already make medical and financial decisions for my child, even though he's an adult. Again, the answer is no. Adults make their own decisions. And then this one, I think somebody asked a question about being expensive. I was quoted $7,500 by an attorney for the whole process. That would be on the very high end, depending on where you are. I think 2,500 to 3,500 is a very market price kind of across the Commonwealth of Virginia. I know some people that will do them for less, specifically if they're uncontested, but sometimes they can get contested, right? Especially, let's say you have, 85-year-old grandma who is, starting to have dementia, and she doesn't think that she needs a guardian. She wants to get her own attorney. She wants to have the medical evaluator, subpoenaed. They can be very expensive, but generally, if it's mom and dad becoming guardian of their soon-to-be 18-year-old, they shouldn't need to be. And I think that's it.
Attorney Thompson.
Yeah, I'm done.
Excellent. I am so glad. I'm so glad that your last slide was getting at misconceptions, because perhaps several of the questions that have already come up have been answered through that slide. But we want to, Christine, let's facilitate some of those questions very quickly. And we're also going to be putting up the session feedback. I see it in my eyesight now. We want to give those of you who would like to take our feedback poll to do so as we're finalizing this question and answer segment. Christine?
Of course. So the first question, can a trustee of a special needs trust be required to consult with a micro board when making decisions?
Yeah, they're customizable. If the settlor wants to make it that way, they certainly can. I'll get back to the question that was asked for Kristen's about the adult child. So your parental responsibilities to any adult children end at 18, disabled or not. Now, does that mean when they turn 18, you're going to just stop letting them live in your home and, helping to pay for their phone if they have one or what have you? Probably not. But are you allowed to do that? Yes. So, if you have mom who wants to continue to support child, mom can go ahead and do that. And if dad doesn't want to, he doesn't have to. And vice versa, right? If dad's the one that's supporting the child, he can. And if mom doesn't want to, she doesn't have to.
Wonderful.
Now that will be good. That will be good information if mom needs to become the guardian of her son. That'll be good evidence that mom has continued to support the child and promoted their welfare, whereas other parent did not. But nonetheless,
Okay.
Go ahead.
Thank you. Thank you. Thank you for returning back to that question.
Yes.
So the next question is, can you describe other mechanisms to ensure the trustee is making good decisions?
Well, the trustees have fiduciary obligations to the beneficiaries. And you can have a trust advisor. This could be a third party, could be the micro board, or some people like to use banks or other professional trustees who can serve as trust advisors to ensure that the trustee is faithfully upholding their responsibilities and their duties. I see another question here. Stephanie asked. So the woman, she said, my clinic stopped taking referrals on October 31st. So fortunately or unfortunately, the clinic decided not to renew my post for the spring. But nonetheless, on the slide there, my email will still be good. Like I said, that's my cell phone. I am still happy to assist people. And don't know if this is public yet, but now it may be. I will be taking over a similar position at the University of Richmond School of Law. So still will be assisting families, and you have my contact information.
That's wonderful. Thank you. The next, I know that guardianship can be expensive. Are there programs that help parents and caregivers pay for that?
I don't necessarily know of programs, but there are, either more affordable options or free options depending on the family's financial situation. Like I mentioned, my clinic, for people that are income and asset qualified, do serve people on a pro bono basis. Typically, if somebody's receiving public benefits, generally they can have even the filing fees waived by the courts. So there would be no charge, but sometimes they have, some income, so they are excluded from public benefits, and the cost is, $20 or $25 or $50. Those resources that I mentioned at the top, your local legal aid societies, all of them, will process you for free guardianship matters. Again, if they're income and asset qualified, so and generally they just then send them to me.
Okay, great. What about supported decision making?
Yeah, so this one comes up a lot, and I know it's a very touchy topic. I do not do supported decision-making agreements because they are typically just agreements to agree, which aren't an enforceable contract or an agreement. And I certainly could, draft those for people, but I don't think they are worth my time or other people's times. And from my conversations with hospitals and care providers, they're not going to rely on those documents. They want either an advanced medical directive or they want a guardianship before they're going to talk to anybody else. And so I asked this question actually yesterday to a hospital's general counsel, and she certainly informed me that they're not going to take any supported decision-making agreement.
Okay, good to know.
Yeah, so I mean, if the person
Yeah,
has the
we have
capacity
time
to understand that document, then they probably have the capacity to sign an advanced medical directive. And that, gives authority to somebody else, but it also, they have responsibilities and fiduciary duties to the person, to the principal, the person who signs it. So it's not like they could just go out and start making decisions that the principal doesn't want them to make. It just gives them the ability to assist them in making those decisions. So for me, it's advanced medical directive or guardianship. We don't do this supported decision-making agreements.
Okay, very good. One last question, I believe. If a guardian and their incapacitated person are moving into Virginia from another state where guardianship is established, and they want to have guardianship in Virginia, what do they do?
Yeah. So that it kind of depends on which state they're moving from. I've had, let's see, so I believe it was New Mexico. New Mexico said, "Oh, you're moving out of Virginia. We'll just terminate the guardianship here, and you can start the guardianship process anew when you get to Virginia." Other states, they have to be transferred in from those states. So ones that I've done recently, Massachusetts, Texas, New York, North Carolina, but basically you file something in the state when you're leaving, and you say, "Hey, look, we're moving to Virginia permanently. Please transfer the guardianship there." Once you get to Virginia, then you file, request for Virginia to accept it, include the orders from the old state, and then it kind of pings pong back and forth one more time. The originating court says, "Okay, you've accepted it. Here's our file. See you later. It's all yours, Virginia." And then there's a final order entered here in Virginia where they've accepted it. But again, it really depends on the state. Some states, which one did I see recently? But they said if you don't file, the request to accept it in Virginia within 90 days of leaving our state, then we're going to terminate it here, and you can just start the process anew in Virginia.
Okay, very good. I'm going to turn this over to Dr. Penny. Thank you very much.
Thank you.
This is a lot of information, and we want to just really thank our presenters for sharing their expertise and their knowledge with us. I was overwhelmed by some of the new information that I learned today, and definitions that I didn't properly understand. So we want to thank you guys for presenting today. There are lots of questions that came in the chat. We are asking if you would please provide the resources and or contact information or anything that you may have so that those who desire to follow up can follow up. That would be wonderful. As always, I call on, I see her hand raised, but I certainly was going to yield to my Executive Director, Terry Morgan. So let's receive our Executive Director, Terry.
Yeah, it's nice to see everybody today. A lot of great information. I do want to say, just to be very clear, that the Virginia Board fully supports supported decision-making as an alternative to guardianship. We think it's a really important opportunity for people with disabilities and families to understand how supported decision-making can allow somebody more autonomy in making their decisions, and that it should be a first consideration, when we're looking at guardianship, how supported decision-making can be used to support somebody in making really important life decisions, as opposed to some of the restrictive natures of guardianship, that do exist. So I really appreciate the information, but I also, don't want to discourage people from looking into supported decision-making as a really viable option. There are some great resources on DBHDS's website with templates and training opportunities and information for families and individuals, and trying to get that information to students when they're in high school and their families, so they can really make wise decisions about next steps and what's best for them, understanding the consequences of all of these different decisions. So I just want to, put that important plug in there for supported decision-making, while recognizing the great information that was provided today, the important information that is really of interest to a lot of people. And we want to provide information that you can take and process and look at within your own personal situation, and how to, develop the best resources and opportunities for you. And I thank everybody for attending today, and also all of the presenters for sharing their information. And, Dr. Penny and Christine, thank you both for everything that you do to make these things happen, as well as the alumni, our alumni.
Thank you. We are so supportive of supported decision-making that it is a part of our Partners in Policymaking training program curriculum. So all graduates of the Partners in Policymaking go through a session related to supportive decision-making. And on April the 11th, 2025, we are actually closing this year's series with our workshop on supportive decision-making. So we encourage all of our participants today, and certainly the marketing will come out, but we would love for you to join us on Friday, April the 11th, 2025. Yeah, 2025 is almost here. We are concluding this 2024 session today, and our next session will be held in February 21st, 2025. We have a two-part session entitled Navigating Justice. Part one is School to Prison Pipeline, and Navigating Justice. Part two is Safeguarding People with IDD and Indivisible Disabilities. That will be held on March the 19th. And then our supportive decision-making will be held on April 11th, all in 2025. And so our marketing will come out with that. Again, on behalf of Virginia Board for People with Disabilities and our training alumni, many of you are on the call today. And I'm so happy to see that you're plugged in, and so happy to know that your commitment to these sessions and to the work that we do to bring them are important to you. So thank you for showing up today and for being here. To our presenters again, to Brittany from Commonwealth Savers, to Kristen, and to Dr. Matthews from All Needs Planning, and to Attorney Thompson from upcoming University of Richmond, outgoing William and Mary. Thank you so very much again for your expertise and for helping us to make this a success. Thank you all for joining us today. Have a good weekend and a wonderful Thanksgiving celebration.